Okay, Attorney Nate Amendola, criminal law in plain English, where it's my job to explain to you how criminal law works using plain English. The question today: can I go to jail at my arraignment? Before we answer that, let's understand what an arraignment is. An arraignment happens after you've been formally charged with a crime, which either happens typically by way of an indictment, a summons, what's called a summons arraignment, or an arrest. So, an arraignment is a defendant's first appearance in court. That is when a defendant will be formally charged with a crime. In Massachusetts, where I am, it will be styled, the Commonwealth versus Johnson, or whatever your last name is. When you are arraigned, you will appear before a judge. The clerk will read the charges, or if you have an attorney there, which we'll talk about in a second, he or she will likely waive a formal reading of the charges. And the judge will look to the Commonwealth, the prosecutor, for an issue of bail. And then the charges will be read, you'll be given a bail warning, and you are officially booked in the system. What that means is a Board of Probation record, a BOP, will be generated, and you won't have a record of convictions at that point, and I hope you never do. But I suppose at that point you've got a record because you will have a Board of Probation record and a PCF number. So the way I like to think about this is for people who have applied to college or private high schools or private school or something. When you apply and you are accepted, and then you go to school, and then you matriculate, you're actually in the school. That's the same way this works. An arraignment is sort of like a matriculation. You're in, and if you can avoid an arraignment, that's a good thing. So, can you go to jail at or after an arraignment? Yes, you can in some limited circumstances. So, at the arraignment, the judge will ask the Commonwealth whether there is an issue of bail. Remember, in Massachusetts and the rest of the United States, bail is, remember, you've got the presumption of innocence. So you're presumed innocent until proven guilty. So keeping that presumption of innocence in mind, what's the purpose of bail? Bail is simply a mechanism designed to ensure that those presumed innocent, which is everybody, are going to appear back in court. The presumption here is that in Massachusetts, a person will reappear back for a future court date based on their own personal recognizance, which is a fancy word of saying their own promise to appear. So if you hear people talk about, just released on PR or personal, that just means their personal recognizance, promise to appear, okay? If the Commonwealth asks for cash bail or conditions, cash bail or conditions of release or some combination of that, your lawyer will, if there's not an agreement on what that is, what the cash amount is or the conditions, there'll be a bail argument in front of the judge. If bail is set, cash bail is set at, say, $5,000, and the criminal defendant does not post that $5,000 at the arraignment, that's when you're going to jail. You are going to be held in jail in the House of Corrections in Massachusetts, typically, until and unless that $5,000 is posted. Okay. The second way is by way of what's called a 58A dangerousness hearing. The Commonwealth, notwithstanding the presumption of innocence, the Commonwealth can move under what's called 58A to hold somebody as dangerous. That's a statute in the Massachusetts law that basically says, look, judge, this person, notwithstanding the presumption of innocence, is so dangerous that we cannot let him or her out back into the general public. It would be a danger to release them. There are these things called predicate offenses. You can't just do this on any crime. The crime generally has to involve force. And there's a hearing where the Commonwealth presents its evidence, and the defense lawyer makes an argument, and the judge is going to determine two things. Is this person dangerous? So that's a designation. Just because judge determines that somebody is dangerous. However, it does not mean that person automatically goes to jail. The other thing the judge is going to determine is whether essentially there are no conditions of release or bail amount that's going to ensure the safety of the public. So if somebody's been determined dangerous and there's sort of no other conditions of release that the court can set that will ensure the public, the safety of a certain individual or the public, that person will be held as dangerous. Pre-trial. This is a pre-trial detention. This does happen. It actually has to happen at arraignment by law. If it's in the district court and there's been a dangerousness designation or determination, that person is held for no less 120 days. If it happens in superior court, it's 180. There is this thing called a bail review, which we'll talk about later, but those are basically the two ways somebody can be held, go to jail at arraignment. There's some other ways too. If somebody's being arraigned for a crime and they've got an open warrant, say in another jurisdiction or a different court in Massachusetts, that person can be held at the arraigning court, held in jail, and then sort of the next day or something is transported to a different court to be answer on the warrant or something like that. But generally speaking, that's how it works. Nate Amendola, Criminal Law in Plain English.